All right, I didn't have much to say in ruling on the motion for advisory jury findings, but I do have something to say on the Google Analytics issue. So I think we all know that it is the obligation of the party to fully and fairly comply with their discovery obligations and to supplement their discovery responses accordingly. The standard is not whether defense counsel only has to turn over what is within their knowledge, possession, or power. It is the clients, the defendants, who must produce that which is within their knowledge, possession, or power. And whether defense counsel knew or didn't know, whether or when Mr. Roddy was asked to create Google Analytics documents in the Texas case is not an excuse. The fact of the matter is, based on the defendant's own filings, the free speech systems corporate designee that defense counsel picked, free speech system employee, e-commerce manager, Mr. Roddy, and the defendant's Texas attorneys were all well aware of the existence of the Google Analytics report half a year ago. But in this case, the defendants filed pleadings with the court representing that Mr. Roddy had no Google Analytics documents, didn't know what the corporate representative was referring to, and perhaps the most egregious representation in the filings states that the defendant contends and has always contended that neither he nor the various entities with which he is affiliated has such data, and that there was nothing more that could be done. The defendants knew of the existence of the Google Analytic documents at a time these representations were made to the court by their counsel. So I'll make the following observation. This stunningly cavalier attitude with respect to their discovery obligations is what led to the default in the first place. The defendants have consistently engaged in dilatory and obstructive discovery practices from the inception of these cases right through to the trial. And finally, I will note there is no notice in this file to this minute of any supplemental compliance producing the Google Analytic documents, which is required by the practice book, but was also required by my clear court order of September 30, 2021, which apparently was not followed here. So the motion is denied for these reasons, and the court hereby sanctions the defendants by precluding them from presenting evidence or argument that they did not profit from the Sandy Hook coverage. All right, and now is this the
Judge,
free
I think
speech?
you granted the motion. You said you denied it.
I'm sorry, the motion's granted.
Thank you, Your Honor.
And then the last